Welcome back. Thanks for staying with us on the AM edition of Newsfeed as we continue to commemorate Women's Day and speak to phenomenal women of change. Now, the Constitutional Court will consider submissions on whether they should consider the UN International Convention on Civil and Political Rights in the Jacob Zuma matter. The former president's lawyers have strongly argued that his incarceration is in violation of local and international law. The court is expected to rule on whether Zuma's imprisonment is lawful. Joining me now is a legal analyst at the International Commission of Jurists, Tanveer Jeewa, to give us a broader picture and understanding. A very good morning to you. Thank you so much for your time. Zuma's legal team has been given a request by the ConCourt and other parties to submit documents. I think it's a 20-page document addressing international law and constitutional implications for his jailing. All of that sounds like a mouthful. What does it essentially mean?
Thank you so much for having me today, Mbo. And I would like to say that it's not unordinary for the Constitutional Court to ask parties to file submissions. But essentially what this means is that the relevant parties who have been asked to make submissions are supposed to basically submit some documents where they've written on whether the court should consider international law and the covenant that you mentioned, what we shortly call the ICCPR, and other submissions as to the rights. So that's it's not as complicated as it sounds, but that essentially is what it means.
So you say that this is something is not something out of the ordinary, but could this then be perceived by some as the Constitutional Court trying to merely excuse the former president? Or is there some legal substance in the former president's lawyer's legal argument?
I think what's very interesting is that when you read the submissions, you see that the Constitutional asks whether it should be considering the ICCPR, which is international law. And if you read the Constitution at Section 39(2), it says that the court must consider international law. So in that sense, it shouldn't be inordinary at all. If anything, the Constitutional Court should always be considering international law, as we have seen from the Constitution, but also from the precedent in terms of the case judgments, the different judgments that the Constitutional Court has written before. So although it doesn't do it consistently, it is supposed to, and it has done so before. Now, in terms of whether that means that the legal arguments are being given due consideration, I think generally that's what we should hope for from the Constitutional Court, in the sense that the Constitutional Court should always be considering, all the legal arguments that have been made in depth before making its final judgment. So I wouldn't rush to say that it's either a good or bad thing for any of the parties, but rather the Constitutional Court just asking for more clarity on possibly any positions that the parties might have.
The former president has been in and out of court essentially for more than a decade now, and his age is something that continues to come to the forefront. His age and his health have been issues that are under the spotlight when it comes to the many court cases that he's had to attend to. Is there some sense of familiarity when it comes to his legal strategy and positioning, considering the two elements that have continued to be raised by his legal teams?
So, I think what's important here, especially given the rule of law, that every accused or every person that's facing sentencing should be the same factors for them should be considered, such as you mentioned, the age and different other factors that should always be considered. Now, I don't want to make any submissions as to whether there is what others would call a Stalingrad tactics, because you've mentioned that the former President Jacob Zuma has been in and out of court before, and in this case has been in and out of jail because he's sick. I don't want to make any submissions as to that, because I think a legal strategy is something that we shouldn't necessarily be making a judgment on, and rather right now really what's at the end of the day is that the last straw for him in terms of this contempt court order is happening right now with the rescission judgment. So I think rather let's wait for the judgment and see what the court has to say. And I would think that, we might hold ourselves in terms of passing judgment in terms of their legal tactic, because we can't really say whether there has been a mistake or whether they intentionally delayed the processes.
Now, former President Jacob Zuma is also expected to be appearing in court tomorrow for a different matter. What do you anticipate in that matter, especially considering that his son, Duduzane Zuma, has been reported to say that he doesn't believe that his father will get a fair hearing?
I think we should generally warn off against people who have been making claims that former President Jacob Zuma will not be getting a fair hearing. I think we have all seen that so far the hearings have been very fair. They've been given more than many chances, even now with the submission with the Constitutional Court, a chance to clarify their positionings. And I think the Constitutional Court and other courts are going out of their way to make sure that these hearings are fair. So at this stage, we shouldn't be really paying any attention to people who are saying that the court hearing won't be fair, especially given to the fact that we haven't actually seen any unfair hearing for the former President Jacob Zuma so far. So I don't have any expectations of any unfair hearing, because that's not, and I'm sure for you as well, what we have seen so far. We've seen only fair hearings.
The Zuma legal team has also put forward a different line of argument, saying that it remains difficult for them to consult with their client, the former president, while he remains detained at the Escort Correctional Center. Is there legal legroom to ensure that there is some sort of balance when it comes to him appearing and not serving his sentence because it's difficult to communicate with him?
I think what's important here is the argument that it's being made difficult for the legal team to consult with former President Zuma. It might be misplaced, because we can, I'm sure, all think of the many other accused who have to consult with their legal teams while remaining in detention. And we haven't really seen any rules or policies put into place to alleviate this. And it would seem a bit unfair to only do so on the basis of former President Zuma himself. So it seems kind of misplaced in this case. And I would hardly imagine that there would be cases where only because it's hard to have a consultation with a client would they allow them not to be in detention. It seems like a bit of a thin ground. I would hate to make any speculation, but at this stage, based on this ground only, I'd find it hard to believe that there would be any policy put into place, or rather him being taken out of detention, only to make it easier for him to consult with his legal team.